Live stream start. Thank you. Morning, everyone. I advise that this meeting of Subcommittee A will be the Licensing and Public Protection Committee will be webcast live, subsequent broadcast on the Council's YouTube site. You can find it on the agenda. And that members of the press, public, may record and take photographs except for their confidential consent items. Members are reminded that they must declare all relevant pecuniary and non-pecuniary interests arising from any business to be discussed at this meeting. If a disposable pecuniary interest is declared, the member must not speak or take part in that agenda item. Apologies were submitted on behalf of Councillor Davis and Councillor Wagg, and Councillors Diane Donaldson, myself, and Councillor Mary Locke, nominated substitute members. Can I welcome you to this hearing of the grant of the sexual entertainment venue licence for Sugar Sweet, first floor, Cumberland House, 200 Broad Street, Birmingham, P15 1SU. Before we start, would everyone please turn off their mobile phones? I'll begin with some introductions. My name is Councillor Diane Donaldson, and I'm chairing the meeting of Licensing Subcommittee A. With me are other members of the subcommittee, Councillor Mary Locke, and Councillor Simon Rock. Also present are the licensing officer, the committee lawyer, and the committee manager. Could I ask all parties to identify themselves, please?
Morning, Chair. David Kennedy, licensing officer.
Firstly, the applicant.
Yes, so Keith Thomas, solicitor for the applicant, and with me is Danielle Collins, who's the director of Sugar Leisure Limited, which is the applicant.
And there's making representations. Jane Kelly.
Beside that, the licensing enforcement officer.
Can I take it all parties have read and understood the licensing committee's procedural rules sent out with the notice of today's hearing? Now, I'll briefly outline the procedure we'll be following at today's hearing. Firstly, the licensing officer will present the report. Then the applicant's representative will be asked to present their case. We're asking if this could be kept to approximately 20 minutes. And those making representations will be invited to present their case. Approximately 20 minutes will be allowed per person for this part of the hearing. I'll regulate the order in which questions are asked by councillors. Please note that members of the committee may question any party following the completion of their submission. I will not normally permit a party to ask questions of the other parties that have made a submission and may direct that question which are not relevant to the application are not formally put or answered. But I point out that occasionally it may be necessary for the committee to take legal advice. I have a question and I ask all parties to withdraw in those circumstances. And at the conclusion of the hearing, I will invite all parties to make a brief closing submission. Can I stress that no decision will be taken until the evidence has been heard? At that stage, all parties, with the exemption of the members, committee manager, and committee lawyer, will be asked to withdraw from the room to enable the decision to be considered. You will then be invited to rejoin the meeting and inform all parties of the decision of the substantive decision and the full reasons will be available in 5 working days. I hope that's reasonably straightforward, so that now ask the licensing officer to present the report, please.
Thank you, Chair. Sugar Leisure Limited has applied for the grant of a sexual entertainment venue licence in respect to Sugar Sweet, first floor, Cumberland House, 200 George Street, Birmingham, B15, or next year. A copy of the application is attached to the appendix 1. Additional documentation in support of the application, including the external scheme, the premises, and the proposed book rules are attached to appendices 2 and 3 respectively. The proposed hours of operation are 7 p.m. which is 12 midnight on Sunday. The nature of entertainment is described on the application form in stage strip shows performed by males. The applicant has confirmed that the relevant entertainment involves full nudity. A plan of the premises detailing where sexual entertainment will take place is attached to appendix 4. The application should be considered in accordance with Birmingham Council's sexual entertainment venue policy. The application was subject to public consultation and advertised in accordance with the statutory requirements as detailed in paragraphs 4.1 and 4.2 of the report. I can advise that no objections against the application were received during the statutory consultation period. The representative of the licensing enforcement team who assessed the suitability of the application has confirmed that they have no objections to the grant of the licence. A copy of their report is attached to appendix 5. The officer is in attendance today should members have any questions to ask about their report. Subject to any new information produced at the hearing, it does not appear that any of the mandatory grounds of refusal apply to the application. The only discretionary grounds upon which the council may refuse an application are listed in paragraph 5.3 of the report. The applicant would have a right to appeal to the magistrate's court against the decision to refuse the grant of the licence and or the imposition of conditions. The applicant, their legal representative and licensing enforcement officer have been invited to attend this meeting. Having heard from all parties present, the committee is requested to consider and determine the application for grant of an SEV licence, having regard to the options available to them, which are detailed at paragraph 6.1 of the report. Thank you, Chair.
Thank you, David. And the applicant, make their representation now, please.
Thank you, Mark. So this is an application for the grant of a sexual entertainment venue licence. I should say that in terms of the normal licences which are granted, this perhaps wasn't originally designed to capture what my client proposes to do. They certainly are very much on the fringes, the outer fringes of what would require a licence, and I explain that for this reason. So my client runs late night premises in Wood Street, has for 17 years. And more recently has been providing entertainment by way of a dance troupe called the Pleasure Boys, who will come along and do a performance, predominantly for a female audience, in the evening. Now that's a stage. When I just try and describe that to you as to what it would be the experience in education, is that it's a ticket-only event, and that's either a £10 ticket, £15 if somebody's going to go and have a meal. That they would go to the premises and they would be entertained by a compere. That compere tends to be a drag artist, and this is entertainment that very much is designed to attract hen parties and that type of audience. The mature version of a hen party, we're not generally talking about the 20 plus, but often it's the 30, 40 plus who would want to come along to this sort of entertainment. Yes, of course, it's a little bit tongue-in-cheek, but it's one that's not, when I look at my client's application and then other SEB applications which I've been involved in, which are lap dancing, private booth, full nudity with one performer and one public, we are two different opposing spectrums. So here, as I say, people who come to premises, tickets only, be sat at a table and have a stage performance with a compere, and then dancers from the Pleasure Boys, which generally is no more than about 3 dances that might take place. And this is a show from start to finish that lasts no more than 1 hour. In terms of the dancing, then again, it's either dancers dressed in uniform, or dancers being builders, or, I paint the picture, and I'm sure you'll understand the point I'm making there, for the stage performance nonetheless. And that is a dance. And in terms of nudity, the nudity is the quick ripping off of the G-string or whatever at the end of a performance, and it's momentary nudity. And then it's more often than not actually full nudity turning around, and then the customers would see it towards the bottom. And that's as much as it is. And that's why I say, when I look at this and I say it's on the fringes of require a license, then it certainly is. Compare that to a private lap dance, which is 3 or 4 minutes plus of completeness in front of an individual, then you see how the two things are very, very different in nature. Now, my client's been operating now for some time, but under the exemptions. So there are exemptions that apply to this type of entertainment. And an operator can have this entertainment 11 times in a year, once per month, but no more than once per month. And if you were to become more frequent than that, then suddenly you become licensed for activity, and you would need an SEB license. And so that's where we are in terms of what we want to do, and hopefully you understand that. So people come to our premises and have that entertainment, and then certainly then go on to do the rest of the evening. Now, in terms of the application itself, Mr. Kennedy's absolutely right. There are no objections to this application. There are no representations we need to consider. And so it's unusual for me then to have that as an uncontested application. But there are certain steps that we need to go through. My client's passed a lot of those in terms of its newspaper advertisement, its notice at the premises. You heard from Mr. Kennedy in his report. What he says is that there are no mandatory grounds for refusal. Now, I appreciate SEV licenses. There aren't very many of these hearings that will do your career as a licensing subject. But there are mandatory grounds for refusal. And there are 3 mandatory grounds. One is whether somebody is disqualified from holding this type of license, which my client and the limited company are not disqualified. The second one is it must be a body corporate that's incorporated in the UK, so a company that's registered in the UK, and we are, so we meet that. And the third one is whether or not they've previously been refused the grant of the license. And they've not previously been refused because they've not previously applied. And so that's why we can say very much so that none of those mandatory grounds apply. So then it's about the only grounds for refusing could potentially only be on a discretionary ground. And there are limited discretionary grounds that a licensing committee is entitled to consider under the Act. And those discretionary grounds are whether the applicant is unsuitable, if they've been convicted of an offence, or for any other reason. Say that either Ms. Collins or the limited company is convicted of an offence, so that discretionary ground doesn't apply. Similarly, when thinking about that, you look to see whether there's any comments from West Midlands Police that would be before you in terms of that type of suitability or any convictions. There are no comments from West Midlands Police on that. The other discretionary ground is whether the licence would be managed or carried on for the benefit of a person other than the applicant who would be refused the grant of the licence if they were to apply themselves. And here I can confirm that this is my client's sole enterprise. The company isn't anybody else. And so we can be satisfied that that discretionary ground itself doesn't apply either. The third discretionary ground is one on number of licensed SEV licenses that you as a licensing authority set within your licensing area. And I should say that that's not an issue for us either, because as a licensing committee, you put a cap on these sorts of licenses of 8 of them in the city. There are currently 6. 5 of them are within the inner ring road, and one is outside. So this would be the sixth within the inner ring road if you were to grant it, and so we still sit well within the cap of licensed premises. And the fourth reason of a discretionary ground for refusal is whether the grant would be inappropriate, having regard to character of the relevant locality, the use to which any premises in the vicinity are put, and the layout, character, and condition of the premises themselves. So, in terms of the character of the relevant locality, and this is Broad Street with all about, which is established and recognised by you as a licensing authority as being the centre of the nighttime within the city, and very much so. It's within the inner ring road, and it's been held to be an appropriate location for SEV licensed premises. And in fact, there are others within the street, as you will be aware. In terms of the use to which any premises in the vicinity are put, I would be submitting to you that there are no sensitive uses in terms of other premises in the locality. And whilst there might be development that's ongoing within the city centre, and it's fair to say some residential, that is not completed, it's not fully in use or fully utilised, and it doesn't change the nature of this relevant locality, which is one that remains, as I say, centre of the nighttime economy for Birmingham as a city. So I'd be submitting to you as a committee that the character of the locality is suitable for what we want to do in terms of the licence we're asking you to grant to us today. The third limb of that fourth discretionary round is about the layout, character, or condition of the premises. And it's fair to say you have the report in front of you from the licensing enforcement officer who has been along to my client's premises, who met with both me and my client, and actually is satisfied that the premises are laid out and their character and condition is such as to support the type of license for which we seek. The entertainment that we are looking to provide is on the first floor of our premises. So there is no visibility into that premises. One does not see from outside any of the entertainment that may go on within the premises at any time. It's also laid out in such a way that the stage areas, and you'll see from the plan that was deposited in the application, there are two potential areas on the first floor that can be used for this entertainment, and they are both in full view of the bar area and DJ area, covered by CCTV camera, and it's one that's supervised at all times. Now, as I've said to you already, my client does not have private booths, for example, where performers might go off with customers for private dances. That's simply not a feature of what my client is doing in these premises. In terms of the application, those are discretionary grounds. It's my respectful submission that none of those discretionary grounds refuse applying this instance either. You can ask yourself some questions which help you to answer some of those questions you go through. And some of those questions to ask yourself in terms of SEVs is, firstly, do you have an applicant before you that is honest and trustworthy? Well, I can say that I've got no comment from West Midlands Police that would otherwise contradict anything about their fitness and suitability to hold such a licence. My client has operated these premises now for 17 years, and in that time, no incidents of any note that come before us in this report that would otherwise go towards them. The other matters that you ask yourself is there appropriate facilities in place for our dancers that would come to our premises? The answer is yes. We have SIA licensed law staff working with the premises. I should add, actually, in talking to my clients, that unusually all of her senior management equally are trained SIA licensed holders. And that is unusual for my premises. It's something that I'm actually congratulating that she's done for herself. There is CCTV and there is changing room facilities for those dancers when they're coming to the premises. You'll see from the application that's before you that my client has put in place rules for her premises. And in terms of the rules, you'll see that they very much go hand in hand with the standard conditions. But in terms of the rules, there are rules there for performers, and there are rules there for members of the public as well. And in fact, at page 18 of the bundle, actually, the SEV rules, and you can see that the performers shall be aged not less than 18 years. The photographic proof of age must be provided, and the record will be kept on premises. That in terms of the performances, that they shall consist of stage performances only. Full nudity is only permitted on the stage. In all other areas, performers must always wear clothing. And no performance will include any sex acts, and there should be no sexual contact with customers during performances. And in terms of behaviour, any persons in the state of either drunkenness or intoxication through drink or drugs will not be permitted to premises. And performers are not to leave with or to arrange to meet customers of the premises. Phone numbers not to be exchanged at the time. With respect to our customer code of conduct, some similar obligations there as well. All customers must be aged 18 or over in order to gain admission. Proof of ID must be shown if requested. My client operates a Challenge 25 scheme, so you'll be familiar with those. As for performances, there should be no sexual contact with the performers during performances, and photographs or recordings of the performers are prohibited. And any person who's either intoxicated, drink, or drugs will not be permitted in the premises, and any person refusing to comply with compliance rules then will be deemed unsuitable for admission to the premises on future occasions. Okay, all sensible rules that go hand in hand with operating something such as this. My client has been through the standard conditions and is satisfied that where they are appropriate to what we want to do here, they apply and we can meet them. I should say that the licensing enforcement officer met my client and my client's the DPS, and again, he satisfied himself that my client is aware of and knows then the standard conditions for license and satisfied that it would be met on this occasion. So, in terms of the other questions you might ask yourself, so one is about trustworthiness, one is about the premises, one is about management of the premises. In terms of management, my client has a management structure. She is the director of the business. She has a senior manager that's worked with her for over 13 years. Our DPS, Steve Emerson, has been in place for over 12 years for this particular role. We have a number of long-serving senior members of staff, which goes to show the type of my client operates in terms of that longevity. So that management structure is in place. CCTV will be heard about. Whether or not there's a transparent charging structure, well, I've already said to you, that's a ticket-only event. It's not the lap dancing venue where you're paying for each dance you're going to have. It's just one ticket entry price. You sit down, you have a show, you then leave in terms of that. So then there's credit structure in terms of the things and the entertainment that we do. So in all of those matters, it brings me to say that all the discretionary matters, I will be submitting to you as a licensing subject that none of those discretionary grounds exist for refusal of the license, and it all points to a grant of the license today. I'm not sure whether you have any questions by myself and client. We're very happy to answer any questions that you have. Hopefully, I will answer most of them. But if there are any questions, I'm very happy to assist.
Thank you, Mr. Wood. Any more questions? So,
Thank you, Chair. Thank you for the presentation. I'm going to start by saying, I must say, the SEV rules, in all the time Life Science Committee, and I'll give it the benefit of the doubt here, but they are very vague. And I think I'll probably advise you to go back and look at that and do it down a little bit more. For example, it says here, there shall be no sexual contact with customers during performances or after the performances, and also you need to explicitly state on the premises, inside the venue, outside the venue, all these sort of things need to be taken into consideration. But again, I'll give the benefit of the doubt. My question is about the scope of this, because this has been framed around in nights, dancing upstairs. You've been in business for a very long time. What's the future scope and ambition for this? In particular, the licensing. This is our stuff here. Let me just find the reviews of 26. Just get to it. 26. Number 28. Full nudity is only permitted in approved designated areas. And towards the end, last time it says, in all public areas within the premises, the performance implies must at all times wear at least a G-string if you're female, or a pouch if you are male. So it's stated both male and female. So this is exclusively female performance, or are you looking to do female performance in the future?
At present, we only do male performances. We were looking to be and the standard conditions apply either way in terms of that. These are your standard conditions that the local authority have adopted. They're pretty much the national standard conditions in terms of SEV type premises.
Yeah, absolutely agree with that. We only work with one dance troupe, pleasure balls. We have no future plans to work with any of the dance troupes. However, if that was to change, they would still be male dance troupes. I have no desire or ambition to be operating premises that allows people to do
just got one. I believe, performances per night. One night, or is it?
So we only perhaps want to do maybe once or twice a month in terms of performances. We're limited under the exemptions of no more than once a month. If you go beyond where there might be some months where you may do it. So it's not the primary business that's conducted here. It's an add-on, occasional nights where you might be able to do this sort of thing. In terms of shows, it tends to be just one show. So 1 60-minute performance. And that's it. I don't think there's not a business to move beyond that. It's one show, one performance, a stage show, and then that's the end. Just, sorry, can I just go back to Councillor Moran's comment in terms of the conditions on the licence. Those conditions about looking at standard conditions actually have been through it. They're very much drawn from the model standard conditions, and they're just reflected. It's very common in the industry up and down the country to do exactly that. And I know you said you give my clients benefit of the doubt in terms of those matters, but generally is accepted up and down, and of course, it's your express wish that my clients be a little bit more explicit in these conditions than they can be.
I would say that was advisory, yes, just in case. Because if you ever got in trouble, just make sure that that's ready.
Those making representations present their case.
No, there are no representations.
And then reverse that. So would you like to make a closing submission?
Well, I mean, it's unusual, isn't it, not me to have anyone who's opposing me. So I think brief actually. I've already addressed you. None of the mandatory grounds apply for refusal. In my respectful submission, none of the discretionary grounds apply either. This is an application with no representation that's before it. West Midlands Police, it's the first time I've ever had them on day of an application that's been lodged to bring me to say no objections whatsoever, which is truly a good measure of the type of client that I have here in terms of where she operates her premises. She has operated 7 or 8 times under the exemption, so she's already demonstrated her ability to provide the entertainment without giving rise for any issues there. Licensing enforcement have satisfied themselves that I'm trying to comply with standard conditions, and I would submit that none of the discretionary grounds apply, and I'd be inviting you and your colleagues to grant the SE license.
Now, as all parties and members of the committee aware, as a manager, to withdraw from the room of the committee makes this decision. I call when you're ready to announce our decision. Thank you.
Great, thank you.